All right, so it looks like you might be dealing with a UK visa or immigration decision that didn't exactly go your way.
Oh, yeah.
I know that can feel like a real punch in the gut.
It's tough.
But before you totally panic, let's unpack how this whole appeals process works. You've got options, and we're going to dive in and figure those out with you.
That's right. Understanding the system is like half the battle. It's like having a roadmap when you're in a new city. Suddenly things become a lot less daunting.
I love that analogy.
Yeah.
And what's super interesting is that the source material for this deep dive is actually a podcast transcript from people today. So we're using a podcast to analyze a podcast.
Very meta.
Now, we're not just talking about like your everyday visa refusals here.
Right.
This source material covers some pretty niche situations. We're talking decisions about revoking British citizenship, appeals for S2 healthcare visitors, even frontier worker situations.
It really does run the gamut. And that's why this deep dive is going to be so valuable. We're going to give you that clear roadmap of the appeals process, whether you're in the UK or appealing from outside.
Exactly. We'll hit all the key steps, those super important deadlines, and even flag some things you might not expect along the way.
Let's kick things off with the bedrock of the appeals process. Any appeal you make goes to the first-tier tribunal, specifically the Immigration and Asylum Chamber.
Hold on. Immigration and Asylum Chamber. Sounds pretty official.
It is.
What is that all about?
It's essentially a specialized court that handles these types of appeals. And the good news is it's independent of the UK government, which means they're supposed to be impartial when making their decisions.
Okay, impartiality, definitely a good thing.
Yeah.
Nobody wants to feel like the deck is stacked against them. But I'm curious, before we jump into the full-blown appeals process, is there ever a faster route? Like, what if you just want a quick review of the decision?
You're thinking of an administrative review.
Okay.
It can be a quicker option, but it's not available for every single type of decision.
Got it. So worth checking out, but not a guaranteed shortcut.
Ah.
Now, let's say administrative review is an option for you. What's the first thing people need to know about the full appeals process?
The first thing is knowing whether you're appealing from within the UK or from outside.
Okay.
The process and even the deadlines are slightly different.
Makes sense. So let's start with someone who is in the UK and has just gotten that decision letter. What are they up against in terms of time?
They've got a tight 14-day deadline
14 days.
from the date that decision was sent to get that appeal submitted.
Whoa, 14 days. That's hardly enough time to process the initial disappointment, let alone figure out this whole appeals process.
You're telling me that's why we're diving into this, to help
Yeah.
you avoid those wait what moments.
Okay, no procrastinating here. So let's say you've gathered yourself and you're ready to fire off that appeal. How does that actually work in the UK? Pigeon smoke signals.
Thankfully, it's a bit more modern than that. The UK has gone digital, so you can actually appeal online through a dedicated service.
Ah, the beauty of the internet.
Yeah.
So you're saying you can submit your appeal online, upload all the necessary documents, even request a hearing, all from your computer.
Exactly. It's faster and generally more efficient than doing things the old-fashioned way.
Okay, that sounds slick.
Yeah.
But what about those who aren't tech savvy or maybe don't have reliable internet access? Are they just stuck?
Not at all.
Okay.
There are alternative options. You can use a different online service or even submit your appeal by post, fax, or email using a specific form.
Phew, that's a relief.
Yeah.
Options are always good. But wait a second. You mentioned a specific form. Does that mean there are different forms for different situations?
You're sharp. There are actually a few different forms, and choosing the right one is crucial.
Okay, that sounds like a potential pitfall. Can we maybe dive into those forms a little bit later? I don't want anybody to accidentally sabotage their appeal by using the wrong paperwork.
Absolutely. We'll unpack those in detail, but first let's talk about hearings. This is where things can get a bit more interesting.
Okay, interesting. I like where this is going. So are hearings automatic when you appeal? Or is that something you have to specifically request?
You have the option to request a hearing when you submit your appeal, but here's the catch. Even if you don't request one, the tribunal might decide to hold one anyway.
So it's kind of that discretion. I guess that makes sense.
Yeah.
But it also adds another layer of what ifs to the process.
Exactly. And when it comes to hearings, there are actually quite a few nuances you should be aware of.
Okay, spill the tea. What kind of nuances are we talking about?
Well, for starters, if you have any safety or privacy concerns, you can request a private hearing or even attend via video link.
Ah, that makes sense. Especially in sensitive cases. You wouldn't want to feel like you're being forced to share personal details, in an open courtroom.
Exactly. And here's a detail that might surprise you. You can actually request a male or female judge if you feel it's relevant to your case.
Wait, seriously?
Yeah.
That's incredible. It's really great that they've built in these options to make the process feel, more accessible and fair.
Right. They've really tried to consider the human element here.
Yeah. Now let's talk about something that no one likes to think about, but is unfortunately part of the process. Fees. Appealing a decision does come at a cost. Okay, money talk.
Yeah.
Everybody's favorite topic.
Right.
But seriously, how much are we talking here? Is it a small fortune or is this something more manageable?
It depends. If you're just submitting the appeal without a hearing, it's £80. But if you request a hearing, the fee jumps up to £140.
Okay, those fees aren't insignificant, especially if you're already, dealing with the stress and uncertainty of the appeal itself.
Yeah.
Are there any circumstances where the fees might be waived?
There are, thankfully. You might not have to pay if you're receiving asylum support legal aid or if you're under 18 and receiving services from your local council.
Okay, that's good to know. It wouldn't be fair if finances were a barrier to accessing the appeals process. What if somebody's struggling financially but doesn't fall into one of those categories? Are there any other options for them?
Yes, there is financial assistance available for those with low incomes or limited savings. So don't assume you're automatically priced out. Always look into potential assistance programs.
Excellent point. It's important to explore all your options. Now, before we move on to appeals from outside the UK, what's the one thing people should absolutely remember when appealing from within the country?
That 14-day deadline. It sneaks up on you fast, so don't delay. Get that appeal submitted as soon as possible.
All right, 14 days. Burn into our brains.
Hmm.
Now let's switch gears and talk about appealing from outside the UK. I'm guessing there are some key differences there.
You bet. But before we dive into those, let's take a quick break and we'll be back in a flash to unpack those overseas appeals.
Okay, so we've covered the basics of appealing a UK visa or immigration decision from within the UK. But what about those who are already outside the UK when that decision letter arrives?
That's a great question, and it's a situation that a lot of people find themselves in. And the good news is the appeals process is still very much accessible, even if you're not physically in the UK.
Okay, that's reassuring to hear. But I'm guessing there are some key differences compared to appealing from within the UK.
You bet. The first thing you'll notice is you get a bit more breathing room when it comes to deadlines.
More breathing room. I like
Yeah.
the sound of that.
Yeah.
So how long do you have to appeal from outside the UK?
You have a full 28 days from the date you receive the decision. And if you're required to leave the UK before you can appeal, you have 28 days from the date you depart.
Okay, that's definitely more manageable than that 14-day deadline we talked about for those in the UK. I imagine those extra 2 weeks can make a world of difference when you're trying to gather your thoughts and figure out your next steps.
Absolutely. It gives you more time to consult with legal professionals, collect supporting evidence, and really build a strong case for your appeal.
Speaking of building a case, does the actual process of submitting the appeal change when you're outside the UK? Like, can you still use that online system we talked about?
That's the beauty of it. The online system is still your go-to, even if you're on the other side of the world. It's all about efficiency and accessibility.
Got it. So same online system, longer deadline. Makes sense. But we also talked about some offline alternatives. Do those still apply for overseas appeals?
Absolutely. If you encounter any issues with the online service or simply prefer to do things offline, you can still apply by post fax or email.
Okay, good to know.
Mm.
But here's where I think things might get a little tricky. Those forms we talked about earlier, I have a hunch they're not exactly the same when you're appealing from outside the UK.
You're absolutely right. They actually have 3 different forms for overseas appeals, and choosing the right one is crucial. Using the wrong form could delay your appeal or even get it rejected, which is the last thing you want.
3 different forms. Okay, now you've got my attention. This is where things could go wrong. Can you break down these forms for us? Like, who should be using which one? Think of it like a cheat sheet for our listeners.
I'd be glad to. So the first form, IAFT5, is specifically for appeals related to being deported under something called the Immigration European Economic Area, Regulations 2016. It also applies if your frontier worker permit or S2 healthcare visitor visa was refused, revoked, or you're facing deportation under those categories.
Okay, so IAFT5 for those very specific situations.
Yeah.
Got it. What about form number 2?
The second form, IFT6, is all about human rights claims for entry clearance or decisions related to your status under the EU settlement scheme. This includes things like deportation refusal revocation or changes to the length or conditions of your stay. It also covers appeals regarding family permits or travel permits under the EU settlement scheme.
All right, so IAFT6 is for EU settlement scheme issues and certain human rights claims. That makes sense. But I'm already sensing a pattern here. A lot of these forms seem to deal with pretty specific situations.
That's exactly right. And that's why it's so important to carefully read through the descriptions and make sure you're choosing the form that accurately reflects your circumstances. Don't just glance at the title and assume it fits. Take your time and really understand what each form is for.
Excellent advice. Now, on to form number 3. When would someone need to use IAFT-7?
IAFT-7 is the form you'd use if you're appealing a refusal of a human rights claim or a protection claim, which is also known as an asylum claim, in situations where you've been told you can only appeal after leaving the UK.
Okay, so IAFT-7 for human rights and protection claims appealed from outside the UK.
Got it. These forms sound pretty specific, so it sounds like picking the right one is absolutely critical.
You're spot on. Using the wrong form is like showing up to a black tie event in jeans and a t-shirt. It's just not going to work.
Perfect analogy. Now, what about oral hearings? Is that process the same as appealing from within the UK? For the most part, yes. The process for requesting and attending a hearing is essentially the same, whether you're appealing from inside or outside the UK. You can indicate your preference on your appeal form, but remember, the tribunal ultimately decides whether to hold a hearing.
Okay, so no guarantees there. But I'm curious, those options we talked about earlier, like private hearings and attending via video link, are those still on the table when you're appealing from overseas?
Absolutely. The tribunal understands that not everyone can easily travel to the UK for a hearing, and they've made sure to accommodate those who might have privacy or safety concerns regardless of location.
Okay, that's good to know. So it sounds like they've really tried to make the process as accessible as possible, even for those who are physically far away. Now, onto the ever-so-fun topic of fees. Does it cost the same to appeal from outside the UK?
The fees are identical, thankfully. Whether you're in the UK or abroad, it's £80 for an appeal without a hearing and £140 with a hearing.
Right, so no difference there.
Yeah.
And I'm assuming those same fee waivers apply, like if you're receiving legal aid, for example.
Well, there's one slight difference there. When appealing from outside the UK, the only fee waiver circumstance is as if you're receiving legal aid. The other waivers that apply within the UK, like being on asylum support, don't extend to overseas appeals.
Okay, that's important to note. So for those appealing from outside the UK, legal aid is your only potential ticket to a fee waiver. Now, I want to circle back to something we briefly touched upon earlier, expedited appeals. This sounds like it could be a game changer for those urgent situations.
You got it. Expedited appeals are a crucial part of the system, and anyone can request one regardless of their location or the type of decision they're appealing. And get this, requesting an expedited appeal is completely free.
Free? Seriously?
Yeah.
I'm all ears. How did this magic work? What do you need to do to get your appeal bumped to the front of the line?
It's not exactly magic, but it can feel that way when it works in your favor. You or your legal representative need to provide the tribunal with very clear and compelling reasons why your case needs to be heard urgently.
So pretty pleased with the cherry on top doesn't cut it.
Not quite. You need strong evidence to back up your request. Think things like medical letters, documentation of extreme hardship, or any evidence that demonstrates your situation is truly time-sensitive.
Got it. Solid evidence is key. So let's say you've gathered all your evidence and you're ready to submit that expedited appeal request. Where's it go? Is there a special expedited appeals department?
Well, it depends on how you submitted your initial appeal. If you're a legal professional and you use the MyHMCTS online service, you can submit your request through that platform. If your client is in detention, you'll need to submit the request by post.
Okay, so online for main HMCTS users, post for those in detention. What about everyone else? Like if you're not in detention and you appealed online as an individual, not through a legal representative.
In that case, you'll need to log back into the online service where you submitted your original appeal. On your account homepage, you should see an option to ask for something else, and that's where you can upload your reasons and evidence for the expedited appeal.
Great. So there's a clear pathway for online appeals. What if you went old school and submitted your initial appeal by post?
If you submitted your appeal by post, you'll need to send your reasons and evidence for the expedited appeal directly to the tribunal, either by email or post. They have a specific address for expedite requests, so make sure you're sending it to the right place.
Got it. So multiple pathways, all depending on your initial appeal method. Now, let's say you've sent off your expedited appeal request. Is there any way to track its progress? Or is it just a black hole of uncertainty?
Don't worry, it's not a black hole. You can always contact the tribunal to inquire about whether your request has been received and to get an update on its progress.
That's reassuring. I imagine it could be nerve-wracking to just sit and wait, not knowing what's happening with your request. Now, before we wrap up this section on appeals, I want to touch on something that caught my eye in the source material. Appeals for applications submitted before April 6, 2015.
Yes. The pre-2015 applications, they have their own set of rules and pathways, which can be a bit of a rabbit hole, but for the sake of time, we'll keep it brief.
Good call. So is it even possible to appeal a decision based on an application that old?
In certain cases, yes. Let's start with Tier 1, 2, or 5 migrants and their family members. If they applied for leave to remain before March 2015 and their application was refused on or after April 6, 2015, they can still appeal.
Okay, so there's still a window for appeals even for these older applications,
Yeah.
but I'm guessing there's a catch.
There is. They can only appeal if the refusal of their application means they no longer have permission or leave to enter or remain in the UK. Basically, it has to have a direct impact on their current status in the UK.
Got it. So it can't be a hypothetical situation. It has to be a decision that actively changes their legal standing. What about the actual appeal process for these older applications? Is it the same online system and forms?
They do have the option to appeal online or by post or fax, but the forms are different. If they're in the UK, they would use Form IAFT1, and if they've already left the UK, they would use Form IAFT3.
Right. Different forms again. It's all about using the right tool for the job, or in this case, the right form for your specific situation and application timeline. What about Tier 4 migrants and their family members? Are there similar rules for them?
There are. If they applied for permission to remain before October 2014, and their application was refused on or after April 6, 2015, they can also appeal, but only if the refusal means they no longer have permission to be in the UK.
Okay, so same basic principle as the Tier 1, 2, and 5 categories. It has to directly impact their current legal status. And are we going to see those same forms pop up again?
You know, they would use the same forms as the Tier 1, 2, and 5 migrants, IAFT1 if they're in the UK and IAFT3 if they're outside the UK.
All right, we've covered Tier 1, 2, 5, and Tier 4. Any other types of pre-2015 applications that might be eligible for appeal?
Yes, a few. They cover a range of other Home Office decisions, but there's a crucial caveat. The refusal can't...
Interesting. So what kind of decisions are we talking about here?
We're talking about things like refusals of applications for leave to enter, basically permission to come into the UK. There are also applications to vary leave to enter or remain, which means changing the length or conditions of your stay, and refusals of entry clearance applications.
Got it. So those more general types of applications. And what about the appeal pathways for these decisions? Are we going to see those same forms again, or is this a whole new ballgame?
They have the option to appeal online or by post or fax, as with the others. And as you might expect, the forms depend on the specific decision and whether they're in the UK or outside. For example, for refusals of leave to enter, they'd use IAFT1 if they're in the UK and IAFT3 if they're outside. But for refusals of entry clearance applications, they'd use IAFT2.
Okay, so yet again, different forms for different situations. It seems like the key takeaway here is to triple check which form is the right one for your specific type of pre-2015 application and your location.
You're absolutely right. It's all about attention to detail. Now let's shift gears and talk about the hearing itself. After all, that's what all this buildup is leading to.
Okay, hearing day. I can already feel the nerves kicking in. Let's walk through what people can expect on that big day. All right, we've covered a lot of ground in terms of actually submitting your appeal. But let's be honest, the hearing itself is what can really make or break things. It's like the main event, the moment of truth. No pressure, right?
Right. Well, it can feel that way, that's for sure. But like we've been saying, knowledge is power. The more you understand about what to expect, the less daunting the whole thing will feel.
Okay, so let's break it down. What are the very first steps once you've actually been scheduled for a hearing?
First things first, you'll get a letter or email with all the nitty-gritty details about your hearing, when and where it's happening, how to attend. Speaking of attending, this is where things get interesting. Hearings can be in person at a tribunal building, but they can also be held remotely via video link or even phone.
Oh, wow. I'm picturing people joining their immigration hearing from their living room laptop, precariously balanced on the coffee table.
That's wild. Yeah, it is a pretty big change from how things used to be. And for remote hearings, the letter or email will walk you through everything you need to know to prepare technically.
So they're not just throwing you into the digital deep end without a life jacket. That's good to know. What about the timing of these hearings? Is the date and time set in stone? Or is there a chance things could get moved around?
It's always a good idea to check the daily court lists on the day of your hearing just in case. You never know. There could be a last-minute change or update.
Good tip. I can only imagine the frustration of showing up all prepped and ready to go, only to find out the hearing's been postponed. Talk about a mood killer. Okay, let's talk about the actual hearing. The people in the room or on the screen, if it's a remote hearing. Paint us a picture. Who can we expect to see?
Well, front and center, of course, is the judge, who might be accompanied by other tribunal members. There will also be a clerk and other tribunal staff there to, manage the proceedings and keep things running smoothly.
Makes sense. Got to keep things organized. And what about the people directly involved in the appeal? Walk us through the cast of characters.
So you and your legal representative, if you have one, will be there naturally. And on the other side, you'll have a home office presenting officer, who's basically the person arguing the case for the home office.
Ah, so it's like a legal showdown. Are there any other key players in this courtroom drama?
If you're calling any witnesses to support your case, they'll be present. And if you need an interpreter, they'll be there to facilitate communication.
Got it. So we've got the judge, the tribunal staff, the legal representatives, the home office presenting officer witnesses, and potentially an interpreter. Anyone else I'm missing?
Well, your sponsor can attend if you have one. And another thing that might surprise you, hearings are open to the public, including the press and media.
Hold on. Open to the public. That's unexpected.
It is interesting, right? I guess it's all about transparency and accountability, but
Yeah.
I can imagine it adds another layer of pressure for everyone involved.
For sure. Okay, so you're sitting there in the hearing hearts, pounding presented their arguments, but then plot twist. The hearing can't be fully resolved on the day. What happens then?
Well, it's not that unusual, actually. Sometimes a judge is unavailable or there just isn't enough time to get through everything. If that happens, the hearing will be rescheduled for another day.
So more waiting. That can't be easy when you've already been through so much.
Definitely not. And sometimes a hearing might be what they call adjourned part heard. That basically means they've started the process but need more time to complete it.
So it's like hitting the pause button and coming back to it later.
Exactly. They'll schedule another hearing with the same people present to pick up where they left off.
Okay, so there are a few possible scenarios, but the good news is the hearing will get completed eventually. Now let's skip ahead to the moment everyone's been waiting for, the decision. How long does it take to hear back after the hearing?
It usually takes about 4 weeks, and you'll receive the tribunal's decision either in person or by post.
4 weeks. That's a long time to stew over everything that happened in the hearing. And what exactly are they deciding on?
They're deciding whether to allow your appeal or to dismiss it and uphold the Home Office's original decision.
Okay, pretty straightforward. A thumbs up or a thumbs down. But here's what I'm wondering. If they allow your appeal, does that mean you automatically get whatever you were originally seeking?
Not necessarily. Allowing the appeal often means the Home Office needs to reconsider its initial decision, taking into account the tribunal's findings. It's not an automatic win.
So it's more like sending it back to the home office with some notes from the teacher saying, hey, you missed a few things. Take another look.
That's a great way to put it. And it's important to remember that both you and the Home Office have the right to appeal the tribunal's decision. So even after the decision is made, the process might not be over.
Okay, so there's always another layer of appeal if either side feels strongly about the outcome. Is there anything else people should be aware of during this decision phase?
Just one more thing. The tribunal can actually order either you or the Home Office to pay the other party's costs if they believe either side acted unreasonably during the process.
Ooh, a cost award. That's definitely something you want to avoid. Okay, let's play out both scenarios. Winning and losing the appeal. First up, what happens if you win?
If you win your appeal, the Home Office has to revise its decision. This often means they'll need to take a fresh look at your entire application, especially if your circumstances have changed since you initially appealed.
So it's a second chance to make your case. What else happens when you win?
Sometimes the judge will order the Home Office to pay you what's called a fee award, which can be up to the amount you paid for your tribunal fee.
No. That's nice. It's like a little consolation prize for all the trouble you went through.
Exactly. And if you win and don't receive that fee award within 60 days, don't be shy about reaching out to the Home Office to inquire about it.
All right, good to know. Now let's flip the coin. What if you lose the appeal?
If the appeal is dismissed, the original Home Office decision stands. But don't despair, it doesn't always end there. You can request permission to appeal to the upper tribunal if you believe there was a legal error in the first-tier tribunal's decision.
Okay, so there's still a glimmer of hope. What kind of legal errors would justify an appeal to the upper tribunal?
There are a few grounds for appeal. For example, you might argue that the tribunal applied the law incorrectly, that they didn't follow the proper procedures, or that their decision wasn't based on enough evidence.
So it's not just about disagreeing with the outcome, it's about pointing out flaws in the actual process.
Precisely. And that's something you'd want to discuss in detail with your legal representative. Now, before we wrap up this deep dive, I want to point you towards some incredibly helpful resources that can guide you through this whole process.
Oh, absolutely. Resources are key, especially when you're dealing with something as complex as the UK appeals process. What kind of resources are we talking about?
Well, all of this information, everything we've talked about today, is covered under something called the Open Government License, which means it's publicly accessible and you can find it all online.
Okay, that's fantastic. Information should be readily available, not locked away in some secret vault. What other kind of resources are out there? Give us the inside scoop.
They have a decisions database where you can see how similar cases have been decided in the past, sort of like peeking behind the curtain of the tribunal's decision-making process.
Ooh, that's fascinating.
Uh,
I bet that database is like a gold mine of information, especially for those trying to understand how their own case might play out.
Absolutely. And they also have all the relevant legislation, tribunal rules, and guidance documents available online. Basically a treasure trove of information.
Wow, they've really thought of everything. All right, we've covered a lot in this deep dive. It's been an intense but informative journey. Before we sign off, let's recap some of the key takeaways for our listeners.
The biggest one always is those deadlines. Missing a deadline can completely derail your appeal. So stay organized, set reminders, and make sure you submit everything on time.
Right, deadlines are no joke. And what about those who are feeling lost or confused by the whole process?
Don't be afraid to get help. Talk to a qualified solicitor or immigration advisor. They can provide invaluable guidance and support throughout the process, and it's worth every penny to have someone on your side who knows the ins and outs of the system.
Solid advice. And finally, even if the initial decision didn't go your way, remember there might be further avenues for appeal. It's not always the end of the road.
Exactly. Knowledge is power, and understanding your options is the first step to navigating this complex system.
So well said. Now, before we let our listeners go, I have one last question for you. Throughout this entire deep dive, what's the one thing that surprised you the most about the UK appeals process?
For me, it's the human element that often gets overlooked. It's easy to get caught up in the legal technicalities, but we have to remember that these are real people's lives we're talking about. These decisions have a profound impact on individuals and families, and that's something we should never lose sight of.
It's so true. It's a powerful reminder that this isn't just about paperwork. It's about people, hopes, dreams, and the right to build a life for yourself and your family. On that note, we'll wrap up this deep dive into the UK visa and immigration appeals process. We hope you feel empowered with the knowledge and resources you need to navigate this system.
Absolutely. Stay informed, stay persistent, and most importantly, don't give up.
Yeah. Until next time.